Welcome back. Tomorrow in just hours, the high-profile Darrell Brooks trial will begin. Brooks is facing dozens of criminal counts, including 6 of first-degree intentional homicide, accused of driving his SUV through the Waukesha Christmas parade this past November, killing 6 people and injuring more than 60. The attack, receiving nationwide attention, has become highly political, and now Brooks, in an unusual move, will defend himself after sparring with the judge in hearings this past week.
Did you hear me tell you about the penalties for hit and run resulting in death?
I don't understand the nature and the cause of the charges.
But that's not my question, sir, so stop playing games with me right now, okay?
Craig Mastantuono is a criminal defense attorney. He joins us now to look ahead to Monday morning. Welcome back to the show.
Thank you.
How unusual is this? We saw this back and forth with the judge. How unusual is it that Brooks will be defending himself in such a high-profile case?
Well, it's not the norm, right? Somebody in his position usually has an attorney that they've been working with, as in this case, for many months preceding trial. The decision to discharge those lawyers and proceed pro se is uncommon. It's not unheard of. We have several examples in Wisconsin and in Waukesha County of people proceeding pro se, if you go back to the James Oswald bank robbery trial. So we've seen this before, and it does happen.
How does this shape how the trial will look in the coming weeks?
Oh, it'll look completely differently than if counsel were proceeding on behalf of Mr. Brooks. You know, fight fans say that styles make fights, and I think that heading into the trial, a fair assessment of both of the sides and the attorneys for the sides were that these were pretty no-nonsense, sober prosecutors and defenders that were going to proceed through this evidence. And now that's taken a complete left turn, because on one side, the defense team has left. And so Mr. Brooks will be alone at counsel table and in a really unpredictable setting. In other words, will he understand what's going on? Will he be able to control himself? How will he conduct himself in the courtroom? And so that style that we were anticipating on one side, proceeding and going through the evidence now, is completely unpredictable.
We saw him this past week raise the prospect of arguing he's a sovereign citizen. What does that entail, and what does that do to this trial?
That is a leftover, if you will, or a holdover assertion, mainly from people who don't want to pay taxes, and created this defense that's been tested over the years. I've never seen with merit or successfully that somebody's not subject to the laws of the United States. And when somebody is in custody for a long time, that can often be something that an attorney has to deal with, because people in custody can hear that from other people in custody, that that's a viable defense. I don't think we're going to see any credence paid to that by the judge, but we'll have to deal with it as she goes, because that asserted defense also involves, therefore, I don't have to do this and I don't have to do that because I'm not actually subject to these proceedings. So the script goes.
This case, as you know, has become highly political as well. You just look to the midterm elections and campaign commercials and what some of the candidates are saying, especially when you look to the fact that he was out on what many consider was incredibly low bail from a previous crime. How much of that will be brought into the trial, if any?
I doubt any of it will make the trial proceedings. I don't think that it would be considered relevant. I think the judge would have a pretty short leash for any party attempting to introduce that, and I don't expect that the parties would.
A lot of unknowns as we head into Monday morning and jury selection begins. Craig Mastantuono, you'll be watching along with us. We appreciate your time today.
You bet.
Up next, RNC preps and Reince Priebus on the midterms.